Hello, this is Mark Lieberman, the host of the radio show, The World According to Mark. And our podcast and radio show today is brought to you through WPVM LP in Asheville, North Carolina. My guest today is Martha Kinsella, a special counsel at the Brennan Center for Justice. And I want to give a little bit more information on Martha, but first I want to thank you for being on the show today.
Thank you so much for having me. I'm delighted to be here.
So the reason that I invited Martha was that she has two very important reports to talk about that were prepared by a special task force, and she'll tell us more about it. But basically, the reports go into a lot of concerns that we've expressed on the show in prior programs about challenges to our democracy, threats to our democracy. We have the Constitution, we have statutes, we have regulations, and then we have things that are referred to sometimes as political norms. And what we have witnessed through the years, but more particularly in the past administration, was an erosion of those norms. And so this task force was conceived, but I'll let Martha tell us about it, in part to try to address some of those issues. So Martha, let you tell our listeners what the Brennan Center for Justice actually is and how that ties into these reports.
Absolutely. So the Brennan Center for Justice is a nonpartisan think tank that focuses on strengthening systems of democracy and justice in the United States, the state, local, and federal levels. And a few years ago, it launched a task force of former senior government officials from both Democratic and Republican administrations. The co-chairs are Preet Bharara, the former U.S. Attorney for the Southern District of New York, and Governor Christine Todd Whitman, the former governor of New Jersey, and the administrator of the Environmental Protection Agency during the George W. Bush administration. They and the other task force members came together to look at various norms that have constrained government officials and ensured that they serve the public interest rather than private or partisan interest, and how those norms evolved, and also the threats to those norms, various breaches and degradation of these practices and unwritten rules that have really guided government officials in effective administration of government programs throughout the years. So they published two reports that document these longstanding principles of good government and the attacks on them, and also proposed a series of legislative proposals to reinforce, revitalize, and codify those longstanding practices.
Well, that's a good introduction. Let's talk about this. Maybe let me help set the discussion. We've known for some time that our system of government is not self-executing, so to speak, that in order for a democracy to function appropriately, we need to have guardrails up. The Constitution is a spare document. It doesn't articulate everything. The Constitution is interpreted primarily by the court system and ultimately by the Supreme Court. There are checks and balances, but in times of great crisis, sometimes the inadequacies of regulation in place or statutes in place, and even precedent and interpretation of the Constitution have not been sufficient to protect against corruption and abuse. And a lot of the abuses that occur in government certainly didn't occur first in the past administration, although that administration deserves a lot of credit, in quotation marks, for helping to crystallize why certain types of reforms may be necessary. And I guess the two reports were prepared while ex-President Trump was in office, but it highlights some issues that still need to be addressed, even certainly within the new administration. And I guess that's really what drove the creation of the task force. Is that a fair statement?
Yes, definitely. The task force documented breaches of various practices and unwritten rules in both Democratic and Republican administrations over the years. It also looked at prior crises, for instance, the Watergate crisis, and the steps that were taken to respond to and safeguard against that. There was a whole suite of legislative reforms that were enacted, ethics reform in the aftermath of Watergate, as well as changes that were made within the executive branch. For instance, the implementation of policies that limited contacts between the Department of Justice and the White House to prevent things like the Saturday Night Massacre from happening again. And for 40 or so years, though, that practice held quite well within the executive branch. But the last several years and in prior administrations as well, the various limitations of both legislative reform that happened in the 70s, as well as executive branch policies have come to light and definitely point towards the need for modernization and further codification of various safeguards.
So you mentioned that things seem to be holding together reasonably well for the last 40 years, but possibly started to unravel a bit, I guess, in the Trump administration. But obviously there was overreaching. There was concerns about impartiality in the Obama administration, the Clinton administration, the Bush administration. But would it be fair to say that many of the things that people view as they use the term unprecedented many times when they're talking about the Trump administration, that he and his administrations in effect pushed the envelope? Is that a fair statement to make?
I do think that there has been an acceleration of testing the limits or reaching standard procedures and protocols. There certainly are some precedents. For instance, the Department of Justice during the George W. Bush administration and White House had a very lax limited contacts policy. And there was a scandal, the U.S. attorney firing scandal, where there was politicized firing of various U.S. attorneys at the Department of Justice, which is something of a precedent. And then also, there was a kind of uproar about communication between Attorney General Lynch and former President Clinton in the lead up to the 2016 election. So, there certainly were some precedents, but I think looking at kind of the acceleration over time of these breaches of practice.
The Lynch and Clinton thing that you mentioned was the infamous or famous discussion that occurred on the tarmac at an airport at a time in which there was an investigation, or perhaps multiple investigations, into the propriety of certain issues involving ex-President Clinton's wife, and that's one incident. But if we take it back to, for example, the Nixon administration, obviously everybody generally understands what Watergate was about. It wasn't just a burglary at the Watergate Hotel, but there were a number of issues that spun off from Watergate. And post resignation of Nixon, and there was a commission or several commissions perhaps to try to address some of the abuses, which included, outright corruption, cover-ups of investigations. You made reference to a Saturday Night Massacre. I'm not sure if everybody listening remembers that, but it was then President Nixon's attempt to try to derail an investigation or try to derail the Department of Justice from doing its duty, and decided to use his power in quotation marks to fire or direct for the firing. And but we've now seen almost exactly the same types of things in the past administration. The new administration is obviously going to have its issues and may already have had its issues. But if we just look at some of the topics which have come up from the prior administration that are addressed in your report, or in the report of the task force, it's there still hasn't been apparently an effective remediation with those. So with those issues. So I can just speak of one, for example, that you might want to address further. The power of the president to pardon. The power of the president to pardon is explicit in the Constitution, as I recall. There is nothing in there that says the president can or cannot pardon himself, although scholars were weighing in on both sides of that, saying, well, of course, it doesn't include the president, because that would be putting some person, in this case, the president, above the law. And that's a fundamental principle. And you don't have to see those express words in the Constitution. It just is. And other people said, no, if it meant that the president, if the Constitution attempted to prevent a president from doing that, it should have said so. But the pardon power is an interesting issue. And the task force had a position that it took on it, and a position, and that's just one example. I guess, again, it's fair to say that most of what these reports go into are recommendations and specific proposals on how to address specific things. One report deals specifically with checks and balances, conflicts of interest, separation. The other report talks specifically about science and how science needs to be protected from partisan entanglements. So let me bring you back to the pardon, just as one of the significant policy issues discussed in the report. Talk to us about that.
Absolutely. So the pardon power has long served as a mechanism to address injustice in the justice system, as well as to heal national wounds. There have been, over the years, for instance, from the late 19th century to the early 20th century, there were certain protocols in place and a fair amount of transparency about pardons. And then there is, even today, a kind of a standardized process for consideration of pardons that goes through the Department of Justice. As we've seen in the past several administrations, for instance, in the Clinton administration with the pardon of Mark Rich, a couple of controversial pardons that President George W. Bush issued, that there have been some controversial pardons where it seemed like there was a conflict of interest, personal interest at stake that motivated the pardon. And there has been public uproar, and at times clemency has been rescinded in the case of President Bush, or in the case of President Clinton, he issued an open letter explaining the reason for the pardons. So I think that kind of shows that while the pardon power in the Constitution is extremely broad, that there is kind of public pressure for the pardon power to be used appropriately, and not for personal or partisan reasons. We saw during the last administration a number of very controversial pardons, pardons of close associates of the president that seemed like they may have been serving to protect the president from legal scrutiny, pardons of other political allies, for instance. And again, there was a fair amount of public discomfort with that. So the task force looked at past practice in the administration of pardons within the executive branch and proposed that in a small subset of pardons that a certain amount of transparency be required, disclosure of information to Congress when the president issues acts of clemency to close associates. And the thinking behind that is that it has a certain deterrent value, that it would deter controversial pardons, but it would also give the information to Congress, which has oversight power, and also the information would be publicly available, so that there would also be an evaluation in the court of public opinion. The task force also recommended that Congress state that self-pardons, there was a disapproval of self-pardons, and that impeachment proceedings would be initiated if there were a self-pardon, again, as a major deterrent against a self-pardon. And the hope with both of those proposals is to, again, constrain against abuse and to really better ensure the appropriate use of the pardon power. I should also mention that there is legislation that was introduced in the last Congress last fall, the Protecting Our Democracy Act, which has provisions that would address controversial pardons as well as self-pardon. So that's certainly an encouraging sign to see that there is legislation that aligns fairly closely with the task force's proposals in this area.
I want to just address a little bit more this pardon issue, because there's something sort of very almost perverse about the way the pardon power has been exercised. When you think, or when I think of pardons in general, I think of the president having sort of the last recourse for persons who are convicted or perhaps indicted but not convicted. It's the last recourse where a particular person might, not just a particular person, but a person's particular circumstances are such that perhaps one last opportunity can be given to an individual to not have to go to jail, not face more drastic punishments like execution. But it just seems to me that normally when an everyday person wants to get pardoned, his or her lawyers have to make a very strong case about why, notwithstanding the fact that that person was indicted, convicted by in most cases unanimous jury determination, and opportunities to reduce the sentences were either ignored or already taken into account, that there's something else, there's some other reason. Maybe the prisoner, if it was a prisoner, was a model prisoner. There were extenuating circumstances that were not admitted at the trial, something like that. In the case of what President Trump did, and obviously in some cases the prior president, it was obvious that none of those factors were taken into consideration. And he just basically was, in effect, paying back somebody for being a good guy by not cooperating, for example, with the prosecution, or cooperating with the government, or just, refuse to flip, or whatever those terms are. Obviously, those types of considerations should not, it should be not part of the whole pardon process. So I think what you mentioned is there is some protocol that other presidents have followed, and there's a commission or two that is supposed to provide advice. But the problem has been is that the president, because of what's in the Constitution, at the end of the day, can choose to completely ignore any recommendations, or not even hear, not even subject, not even give anybody else an opportunity to say, Mr. President, we don't think that a pardon is appropriate in this circumstance for the following reasons. That's really what's core here, isn't it?
Yes. There is, as I mentioned, there's a standard process at the Department of Justice where there are certain factors that are taken into consideration. And I should also mention some of my colleagues at the Brennan Center have worked on looking at pardons and acts of clemency and how it could be a tool for justice in addressing some wrongs within the criminal justice system. There's also a lot of thinking about additional uses of the pardon power, but again, looking at a lot of different criteria to really be a tool for justice rather than injustice, and upholding the rule of law rather than subverting it. What we've seen, from what I understand from the Trump administration, but also, even going back to President George H.W. Bush's pardons related to the Iran-Contra scandal, those were pardons where the standard procedure for evaluating pardons was pushed to the side, and it was kind of handled very differently from the standard pardon procedure. And so there wasn't the similar weighing of factors that typically comes into play.
So for those just tuning in, my guest is Martha Kinsella from the Brennan Center for Justice, and we're talking about her knowledge and understanding and her work on two reports that were issued by a special task force that was chaired by two esteemed individuals, and had 3 or 4 other folks, all of whom were chosen or came together because they had an extensive career in government and justice, and according to what I read in the report, were considered to be nonpartisan. Can you talk about the makeup again of that task force besides the co-chairs?
Yes. So in addition to the 2 co-chairs, there were 6 other members of the task force who also served in both Republican and Democratic administrations, and had also served. Some of them had served as state executives as well as in Congress, and we had, I guess, like a 50-50 split between people who had served in Republican administrations and Democratic administrations. There was also a diversity of backgrounds, people who had experience working in the Department of Justice, as well as people with ethics experience, people who ran federal agencies that were research-oriented agencies, and so they felt very strongly about protecting government research from undue politicization. And the majority of them had also gone through the Senate confirmation process, and so they were very much aware of the dynamics between the executive branch and Congress, and the Senate specifically in the confirmation process, but also the dynamics between legislators and then implementing legislation in the executive branch. They had several cabinet secretaries, as well as people who served as senior policy aides. And it was really, their diversity of experience was really very valuable to coming up with a series of very thoughtful, but also common sense and workable reforms for the government.
So again, I need our audience to understand the breadth of these proposals. My overall take on it is that the proposals are a very earnest and extensive or substantive attempt to bring transparency to all aspects of our government where transparency is not there. The protocols might have been there, or the way people behaved in previous administrations might not have suggested we needed that. But if we needed a further illustration of why these reforms are so fundamental and so necessary, again, I think just a history of concerns that have been raised or were raised about the Trump administration almost from day one provides the table of contents. So just to give another example, neither President Trump nor Mike Pence provided tax returns. They adamantly refused to do so. And as it turns out, there was no law that required them to do so. So they didn't provide any reasonable or rational reason for not doing so. We know that President Trump said he couldn't at the time because it was under audit, which turned out to be sort of a nonsense concept altogether. And for the entire period of his administration, they were never released. They still haven't been released. They've only been now provided under seal, so to speak, to investigators that are looking at the Trump organization. Well, other presidents did it, including President Nixon, had released their tax returns. The argument I've heard is, well, we knew what we were getting. We knew he was a businessman, but that really is beside the point. This report tries to explain why the provision of the tax returns of the president and the vice president are fundamental. It's not just a thing. So can you talk about that?
Yeah, so actually this week, President Biden and Vice President Harris released their tax returns as a return to the practice that, as you mentioned, goes all the way back to President Nixon of providing that really basic level of transparency to the American people. There's a lot of information that the American people can learn from tax returns, tax return disclosure, but also there's just a kind of a show of good faith that the president is playing by the same rules as everyone else, in paying their fair share in taxes. And I think that it speaks volumes that there was this unbroken precedent from President Nixon up until 2016 that has also resumed with the new administration of presidential candidates disclosing their tax returns, and then also presidents disclosing that information to the public. But as we saw during the 2016 campaign and then during the Trump administration, there's really a need for that practice to be codified in order to ensure that people continue to provide that information to the public. And there have been bills that have been introduced in the last couple of years with some bipartisan support that would require disclosure of tax returns for presidential candidates as well as presidents. There's also a provision in the Omnibus Democracy Reform Bill, the For the People Act, that would mandate tax return disclosure for candidates as well as presidents.
So I could think of at least two fundamental reasons why providing the tax returns were important. First of all, we did learn, at least, and I'm not sure how reliable it is, that that President Trump paid something like $778 in some recent year. But one of the fundamental reasons is you want to determine whether the president and the vice president appropriately paid their, quote, fair share of taxes and didn't use loopholes that were really not loopholes, but basically committed any kind of tax fraud. And if you don't have a system in place that audits, that process, or at least provides transparency and let experts, accountants and tax lawyers and the like evaluate, you don't know. And we also know that President Trump didn't help his case for being upright and paying his fair share of taxes by making comments like only idiots, pay all their taxes. So the reason I didn't have to pay very much is because I'm smart, which is obviously a nonsensical, irrelevant type of comment to make. The second reason is that with the tax returns, you're the population, the electorate, the voters, people who care about these things can look to determine whether or not there was any inappropriate revenue or money that was received, any foreign entanglements, any domestic entanglements, anything that could potentially have an impact on how the president ultimately behaves in office. So those are important things. But we've gone now for years where we've trusted the presidents and we've relied on the presidents to self-disclose. The Trump administration proves that that is not sufficient. And without providing that, and then a couple that, and I think the report addresses this as well, is President Trump, unlike other presidents, never really divorced himself from his other businesses, putting his businesses in the hands of his two sons, or putting things, even if they were put in a trust, which I don't believe they were, doesn't remove the president from potential significant conflicts of interest in policies and protocol and appointments and all the rest of that. So the task force is saying what should happen going forward, that the tax returns have to be reported. And they probably also comment upon this issue of the extent to which the president can continue to have interests in companies that he could potentially influence through his presidency.
Yeah, so another proposal that the task force put forward is to extend federal conflict of interest law to the president. Up until now, there's a carve out for the president in conflict of interest law, federal conflict of interest law. But presidents up until President Trump voluntarily complied. They divested, or they invested in plain vanilla assets, and he did not. And that really raises a lot of questions about commitment to the public interest, making decisions in the public interest rather than for personal, familial, or for partisan reasons. So that's another proposal that the task force had to codify this longstanding practice. And again, the People Act contains a provision that would do exactly that, that would extend conflict of interest law to the president and the vice president. I should say, kind of taking a step back, zooming out, that I think there's a kind of a guiding principle across many, if not all, of the proposals in the task force's work, this belief that there should be greater transparency, that there has been declining trust in government, which I think charts back to the Watergate era, but has eroded, unfortunately, since then. And that to restore that trust, there needs to be greater transparency and democratic accountability and proof that the government is working in the public interest rather than on behalf of special interests or personal interests or partisan interests. And so that, I think, was a primary motivation in the crafting of these and other proposals. And certainly the various things that presidents and senior executive leaders have, the steps that they've taken kind of voluntarily or through executive branch regulations over the years that have provided some measure of that assurance. That was definitely a guidepost in thinking about what the next steps are to really like reinforce and solidify those practices and to provide further guarantees to the American public about government officials' commitment to public service.
Well, let me take a sidestep here, and I do want to go through some of the more important proposals, although they're all important in both of the reports, and we haven't even really gone into the report on the integrity of science, and just say that the purpose of the report, I would assume, are several. One is to get a group of educated people who have deep and wide experience in the government to look closely at some of the major problems that we've been having in this country. And you just put your finger on it. It's a question of trust. Can you trust that your elected officials are acting for the best interest of the country as opposed to their own self-interest? And the answer is, I think, obvious. No, unless there is full disclosure, unless there's transparency. Everybody knows that there are certain things, functions in government and certain functions of the presidency that require confidentiality. Not everything can be done out in the open, particularly matters of national security. But the one fundamental thing is there's got to be transparency in terms of evaluating what's going on, what could possibly be influencing the president in this case to act in a certain way. And the mere fact that people questioned, well, why was Trump so cozy, and it's still being asked, with Putin? Is it because he liked Putin? Is it because he respected some of his authority that he had that Trump evidently wanted to emulate? Or was it because of something more nefarious, that Putin had something on Trump, or Trump owed money, or Trump was bailed out? You can't know that unless the processes are more open and more transparent. So your report is, on the one hand, meant to try to influence, I guess, a discussion, an education at all levels. It's also presumably, and you've alluded to it, meant to help influence legislation. So how realistic is the idea that these reports, as well as thorough as they have been, are actually going to result in legislation, new regulations that are codified, to use the term you used earlier?
That's a great question. So I think, I guess as an initial matter, I would just point out that the Biden administration has taken certain steps that they've issued executive orders that align with a number of the proposals in our report, which I think is a positive sign about the new administration's commitment to restoring these guardrails. But it's not enough, because, as we've seen with changes in administration, there can be different levels of commitment to these basic guardrails. But it is certainly a positive, encouraging sign that the Biden administration is doing what it can to restore some of these guardrails, and certainly possibly an indication of where the president would be if a bill actually came to his desk. In Congress, I think that it's important to note that these proposals are kind of nonpartisan in nature. It is a two-way street. I think that much as Democratic lawmakers were horrified by some of the abuses of power during the Trump administration, I would believe that Republican lawmakers would be similarly outraged if a Democratic president committed the same types of abuses in the past. I think that they have been. And so I think it's really in everyone's interest to put in some constraints on executive abuse. And there is some bipartisan movement on a number of on legislation that aligns with a number of the proposals in the reports. For instance, in the realm of the politicization of science, there are bills that have bipartisan support, in some cases quite strong bipartisan support, for instance, with respect to federal advisory committees. I do also think that it's helpful that there has been buy-in in the past from both Republican and Democratic administrations for a lot of these basic guardrails. Democratic as well as Republican candidates for president and presidents disclosed their tax returns and voluntarily complied with conflict of interest law, and had limited contacts policies to insulate the Department of Justice from politicization from the White House. So there is definitely precedent for bipartisan buy-in on these reforms. There are some positive signs in Congress. And I think we'll just kind of have to see how things shake out. There are some bills that are quite comprehensive. The Protecting Our Democracy Act, for instance, is one bill that really speaks to a number of the issues that are addressed in our reports. And then there are other bills that are kind of one-off, dealing with one issue or another. And it does seem like there are different political compositions of members of Congress who get behind one or another reform. I think that there are many different strategies for how to get these various reforms implemented. I think another important aspect to all of this is to really make the case in the court of public opinion, so that there is kind of pressure from the ground up for reforms to be put in place, and the sooner the better. There's certainly a lot of momentum coming out of the last administration, and certainly I think that the COVID-19 pandemic really exposed a lot of these fissures and the need to really rebuild trust in government and to ensure the proper functioning in service to the American people. So I do think that there's definitely a moment to make the case both to the public and to lawmakers that these reforms are really critical.
So let's pick up for a moment, at least on the science element, because you mentioned COVID as an example. The reports were issued in 2018 and 2019. I think the science one was the latter of the two. And one of the types of things that were addressed in the report, at least as predicate for why there needs to be further regulation or codification of laws, was the climate change. Because there are instances, we know of instances in which not only President Trump, but people in his cabinet, the head of the EPA, whatever, basically delegitimized the concerns about climate change as it pertained to the positive connection between industrial pollution and man-made efforts that denigrate the environment. And we know, and the report points out, a couple of instances in which the proper functioning of what should be regarded as somewhat independent agencies was interrupted, was muzzled. People were moved out of their position. Can you talk a little bit about that? And then I want to bring up how COVID also was affected.
Yes. So I do think that the assault on the nonpartisan scientific research that has really been like a jewel of the American federal system it's longstanding. Our report documents episodes of abuse going back 40 years, or maybe even longer, in both Democratic and Republican administrations. But it's definitely very disturbing. We've seen editing of reports by political officials, silencing retaliation or threatened retaliation against career scientists who have been very dedicated to public service and have been doing research in the public interest. And it really impacts what the federal government can do if political officials are kind of forcing the agency to rely on junk science that has been edited for political purposes. And certainly it impacts public health and the environment and consumer and worker health and protection, safety, when there is this kind of politically motivated meddling in what should be nonpartisan government functions and services. I think also it really undermines trust and credibility in the federal government if it's not able to have science and evidence-based policymaking. And during the Trump administration, there were some very disturbing tactics that were employed. Entire research units were moved across the country from Washington, D.C. Hundreds of scientists' lives were uprooted, and it caused very serious attrition because people couldn't uproot their families within just a few months' notice. And it did seem like it was in retaliation for the research that they were doing that was kind of at odds with the administration's political agenda. I think those are some of the most extreme cases, and it's kind of hard to imagine how to undo that, because some people did move across the country and then other people didn't. They found other jobs. I mean, it's just a tremendous loss of institutional knowledge in the federal government.
Well, let me say this. I think that a lot of the damage that was done to the credibility of science was just rhetorical flourishes by the ex-president and by other folks that he appointed to various cabinet positions. Basically, he helped to discredit or tried to discredit, and we're still living with that. The issue of whether or not there is or is not climate change. We know that things that President Trump said and did, and the way he was able to influence other individuals within the government to do things like, take any mention of climate change. I may be extending it a bit far, but any mention of climate change on official government websites, the almost comical issue where President Trump used his Sharpie to suggest that the hurricane that was hitting southern United States was on its way to Alabama. And it turned out that was, completely wrong. It was against what all the meteorological predictions were. But not only did he do that, but then there were threats made to the National Oceanic Administration, if I have that correct, individuals who threatening them that they needed to back him up on that false assertion. And people, again, either lost their jobs or relocated to a desk job. That's pretty hard to swallow, so to speak. And I'm not sure that government regulation and new laws necessarily address that if you have a president who, in my opinion, is going rogue. And the further problem with that was in the case of COVID. You had the president not only discrediting Dr. Fauci, not only talking badly about the CDC, but you had the president making completely false assertions about COVID and treatments for COVID and the fact that it would go away. So we basically threw, it's one thing to say we don't want scientists, governing, but it's another thing to just completely trash it. How are these proposals going to change that, do you think?
Yeah, so that's a great question. And I do think that the damage really has been tremendous. I think vaccine hesitancy, that's quite possibly an outgrowth of just a really sustained assault on research and data collection that the government does. And there are so many other examples of just profound lack of trust that I think is a result of this politicization of government programs that in some cases have been around well over 100 years. I think, well, one of the proposals that we have in the report looks at an executive branch policy that was put into place during the Obama administration in response to some pretty serious abuses during the George W. Bush administration that it required agencies to create scientific integrity policies that basically laid out kind of a Bill of Rights for government researchers and created protocols, procedures for investigating allegations of attacks on science, and they have been fairly successful. If I'm not mistaken, I believe even there was a scientific integrity investigation and finding using the scientific integrity policy at NOAA as a result of Sharpiegate that you mentioned. But again, they're not enough. The scientific integrity policies, there's a lot of variability from one agency to the next in the level of detail and how effectively they've been implemented, how much scientists at the various agencies feel like they have adequate protections and recourse under them. So the task force looked to codify that requirement. And I should say, and that was the requirement across the government that there be scientific integrity policies at every agency during the Obama administration. The Biden administration has issued an even stronger memo on scientific integrity and has a scientific integrity task force that met just last week and is really evaluating how to rebuild after so much damage. So, I think that's also a positive sign, and there's always something to be learned from what's actually worked in the executive branch, that can inform legislation. So, to return to the task force and its thinking on this, one proposal was to codify that requirement that there be scientific integrity policies, and I'm pleased to say that there is a bill in the House, the Scientific Integrity Act. It passed the House last Congress, and it does have limited bipartisan support. But that's something that I think if it were implemented, that it really would do a great deal to lay out, as I said, like a Bill of Rights for scientists, and then also create a procedure for reporting and remedying these attacks on science. The task force had a number of additional proposals for legislation. One abuse that we've seen during the Trump administration during the pandemic, but also to a more limited extent in prior administrations was, so there are these advisory committees, science advisory committees of outside experts who come and advise the federal government on science in policymaking. And we've seen the firing of eminent, esteemed scientists and the replacement with either partisan hacks or people who are very heavily tied to the industries that are regulated by the agencies where these science advisory committees are housed. So the task force put forward a proposal to improve the functioning of these committees, requiring much more transparency, more scrutiny of conflicts of interest, disclosure of that information to address a lot of those abuses. And again, there is legislation in Congress with robust bipartisan support. Has also passed the House in the past couple of Congresses under both Republican and Democratic control that would accomplish a lot of those objectives that the task force put forward. And I should say, with respect to advisory committees, the task force looked at kind of best practices across agencies, which agencies had historically had very high functioning advisory committees, and how they did it, how they recruited top talent, et cetera, and made recommendations to kind of codify a lot of those practices.
We just have a few minutes left, and there's perhaps one other point I wanted you to make, but I want to again let my listeners know we've been talking with Martha Kinsella, who is counsel to the Brennan Center for Justice, and we're talking about a terribly important set of issues dealing with our democracy, checks and balances, and she and her rendered assistance to that task force to produce 2 reports which people need to read. Why don't you tell them now, before we conclude, where they can get that information?
Yes, so the reports are available on the Brennan Center's website. We have a page dedicated to the National Task Force on Rule of Law and Democracy, and the reports can be found there.
So that information should be read by every person who considers themselves to be a good citizen and active for change. Even if you don't agree with some of the proposals, even if you think that they don't go far enough or they go too far, that to me, this would be a good starting point. And for colleges, high schools, community organizations, whatever, to understand what the assaults have been, not only what the assaults have been, I think we know about them, but what possible solutions there are. Because people always say, well, what can you do about it? Well, one of the things that can be done is you can talk to your legislators, you can write op-eds, you can volunteer. You can volunteer for the Brennan Center to protect their mission, because they've done an amazing job in terms of fleshing this out. So one last point before we close. One of the other things I think you need to look at in these reports is the way in which, I'm going to say, the Trump administration specifically has abused the power to go after individuals through the Justice Department, through the FBI. Nixon had his enemies lists. People have been, told the presidents have told the IRS to go after people. But I think what we saw in the Trump administration was unprecedented. If you can just comment on that in 10 seconds, I'd appreciate it.
Yes, so definitely we were very interested in politicization of the Department of Justice. Again, that's really undermining a core principle of American democracy, that we have the rule of law, that no one is above the law and no one is subject to bills of attainder, basically, or persecution
or retaliation.
Right. Mm-hmm.
Martha, thank you very much. Martha Kinsella from the Brennan Center for Justice. Thank you very much for being on the show. I want to thank my producer, Focus Solutions, Mark Lieberman. We'll have you on the show again. This has been fascinating. Thank you.
Thank you so much for having me.